Hello friends, today we will discuss writs under the Indian Constitution. Writ is Latin for we order. Writs are orders issued by a legal authority and most cases that is a court of law. Now what do these writs do? These are orders which tell a person or an entity to do or not to do something. Indian Constitution empowers the Supreme Court under Article 32 of the Constitution and High Courts under Article 226 of the Constitution to issue writs. Now, friends, as you all are aware, Part 3 of the Constitution under Article 12 to 35 deal with fundamental rights, which are essential and basic human rights granted to all citizens of India. Now, what would happen if these rights are violated? The Constitution, in fact, provides Article 32 as a fundamental right wherein a person can directly approach the Supreme Court in case their rights are, that is, their fundamental rights are violated. The Constitution also empowers the High Court under Article 226 to protect the rights of the citizens by issuing writs. But friends, there is a slight difference in the writ jurisdiction of the High Court and the Supreme Court. First, Supreme Court can issue a writ only in cases where fundamental rights have been violated. High courts, on the other hand, can issue writs not only for the enforcement of fundamental rights, but also in other cases of injury or any illegality that might have been committed. Second, Article 32 is a fundamental right and hence Supreme Court is obliged to entertain the writ petition and issue writs in cases where the fundamental rights have been violated, whereas high courts are under no such obligation. They can refuse to exercise their power to issue writs. And third, high courts have territorial jurisdiction, meaning they can issue writs only if the person or the government against whom the writ has been issued lies within its jurisdiction, or in cases where the cause of action arises within its jurisdiction, whereas Supreme Court can issue writs against any person of government throughout the country because their jurisdiction extends throughout the territory of India. So friends, whenever fundamental rights are violated, people can directly approach the Supreme Court, but in some cases, they will also be answerable as to why they came to the Supreme Court directly rather than approaching the High Courts. Now let's look at the writs that are provided under the Constitution. The Constitution of India empowers the courts to issue 5 kinds of writs. Let's look at the first one, habeas corpus. This is a basic translation of habeas corpus is to have the body of. This is often known as a great writ or a defender of fundamental rights writ because it protects a person's fundamental right of freedom or liberty. It protects a person from being detained unlawfully. Under this writ, if a person is detained unlawfully, then he or she, or in case he or she are incapacitated, his or her family members like mother, father, siblings, children, wife, etc., can file a writ petition in the Supreme Court. After examining the writs, if the courts feel that their petition is valid and justified, then they can issue a writ of habeas corpus. By issuing this writ, the court can order the entity who has detained or arrested the person to produce that person before the court and give reasons for the imprisonment or arrest. The aim here is to determine whether the person who has been detained lawfully or not. Here the onus of proof or responsibility to prove that a detention is legal is on the authority who has arrested. But it is very important to note here that this writ just orders that the person who has been illegally detained is released, but it does not exonerate the detained person from guilt or liability. Another important thing here is this writ can be issued against a person or authority, and therefore if someone has kept another person illegally in their home, a writ of habeas corpus can also be issued against that individual. Friends, it's also worth mentioning here that Article 22 of the Constitution of India also protects the right to freedom of citizens of India by ensuring that no person will be detained in police custody for more than 24 hours without being produced before a magistrate. So friends, this is all about the writ of habeas corpus. Now let's look at the second writ that is mentioned in the Constitution, that is the writ of mandamus. Mandamus in Latin means we command. Basically, this writ is issued by a court to instruct, command, or order or mandate a public officer to perform their duties. It cannot be issued against any individual or person. So, if somebody is not doing, a private person is not doing what I'm asking them to do, then I cannot request the court to issue a writ of mandamus. This can only be issued against a public body, corporation, an inferior court, tribunal, government, that is, the public bodies who are not doing what they are supposed to do. Then comes the writ of prohibition. Prohibition means to forbid. Here, the court with a higher jurisdiction can issue a writ, that is the writ of prohibition, against a lower court or quasi-judicial bodies like tribunals. In those cases where they feel that the lower courts are going beyond their jurisdiction, it prohibits those courts from continuing with their proceedings, and it is very important to note here this writ can only be issued in those cases where the proceedings are still going on and the judgment has not been passed by the court. Then comes the writ of certiorari. Certiorari means to be certified or to be informed. So friends, as we saw in prohibitio, writ can be issued only if the proceedings are continuing before the court. Now, what would happen if the case is closed and a final judgment has been passed, and after that the aggrieved party finds out that the court acted in excess of its jurisdiction? In such situations, the writ of certiorari comes to the rescue of the aggrieved party. Here, the aggrieved party can file a writ of certiorari in the Supreme Court or High Court, and after assessment of the petition, if the court feels that the lower court has acted in excess of its jurisdiction or capacity, then it can issue a writ of certiorari to quash the order or the judgment of the lower court or tribunal. Friends, this writ can only be issued against judicial and quasi-judicial authorities. So friends, the high courts can issue a writ of certiorari and transfer such cases to itself where it feels that the lower court is functioning either under lack of jurisdiction or excess of jurisdiction. So friends, before 1991, certiorari could only be issued against judicial and quasi-judicial authorities. But after 1991, the Supreme Court ruled that the writ of certiorari could also be issued against administrative bodies where the rights of individuals have been impacted, whereas the writ of prohibitio cannot be used against administrative bodies. Now friends, prohibitio is only preventive in nature, but certiorari is both curative, that is, to cure or mend the wrong of lower courts, and is also preventive because it prevents a wrong from happening, wherein the high courts can transfer a case to itself where they feel that the courts are exercising their powers in excess or beyond their jurisdiction. Then comes quo warranto. It means by what authority. This writ challenges the legality of any public office being occupied by a person. Now friends, any person, whether they are directly impacted or not by the appointment of an officer to a public position, can file this writ before the Supreme Court or the High Court, challenging that the appointment of this person was not done in a fair manner. And his appointment will have an impact on the fundamental rights of the people. So through this writ petition, the court can inquire into the legality of appointment of that person to a public office, and if they feel that it is not correct or properly done, they can issue orders accordingly. But it is important to mention here that this writ cannot be issued against private individuals. It can only be issued in those cases where the public office is of a permanent nature and is created either by the statute or constitution. So friends, I hope this video gave you a nice understanding about the writs that can be issued by the Supreme Courts and High Courts under Article 32 and 226 of the Constitution of India. I hope you liked the video. Thank you so much for your time, and I'll see you soon with another video. Till then, goodbye, take care, and have a great day.